Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm presiding judge here in County Court at Law Number 2. This morning, we have what is called an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offense. Does not mean that they're not serious. It just means that they're not as serious as a misdemeanor as a felony case. Now, when I use the term serious, what I'm talking about facts of the case and the possible punishment that a person can get if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. If a person is convicted of the state jail felony, then the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment minimum is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those type of punishment because, as I mentioned to you earlier, your case is a misdemeanor case. Now, misdemeanors are divided into 3 categories. We'll start at the top, work our way down to the bottom. You have the class A misdemeanor, the class B misdemeanor, and the class C misdemeanor. With the class C misdemeanor, the range of punishment is by fine only, and a fine cannot be above $500. Now, class C misdemeanors are cases that start in the city court or the JP court, and they come to this court when a person is convicted in the JP court or the city court, and then they appeal their case. And if they appeal their case, they get a whole new trial in this court. And the punishment range does not change. It's still maximum fine of $500. Now, the next highest misdemeanor is a class B misdemeanor. With the class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days, or you could be given a fine that does not exceed $2,000, or you could be given both such fine and jail time. Now, the highest misdemeanor is a class A misdemeanor. With the class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or you could be given a fine that does not exceed $4,000, or you could be given both such jail time and a fine. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation. And the other type of probation is called adjudicated probation. Adjudicated probation. So the difference between the 2 is as follows. With the unadjudicated probation that we commonly refer to as deferred adjudicated probation, it does not result in a conviction on your record. And if you successfully complete the probation, the case will be dismissed. You will not have a conviction on your record, and you may qualify for what is called a non-disclosure. What a non-disclosure is, it basically means that your record is sealed to the general public, so the general public cannot have access to your record. And the next type of probation is called adjudicated probation. With the adjudicated probation, it does result in a conviction and record. However, there is something that is called judicial clemency. Judicial clemency means that the judge can set aside the conviction, which means you will no longer have a conviction. And if you successfully complete the probation, and if there's no more time left on your probation, and if the probation office successfully discharges you off of probation, you can qualify, and the judge has the discretion to grant you grant you a non-disclosure. Now, judicial clemency. Now, however, if you get a subsequent conviction, which means that if you get another conviction later on after you receive judicial clemency, then if you try to get a license with CPS, Child Protective Services, they can deny giving you a license, or if you have a license, they can revoke or suspend your license. Okay, now the paperwork, everybody here for a case should have a clipboard. Who does not have a clipboard? Okay, you here for a case? Okay. There's a clipboard over there. I think that's the nearest one I see. You can go and get that clipboard. Okay, anybody else? Okay. Now, that paperwork on the clipboard, you have 3 documents. One document is called Judge's Explanation of Rights to Defendants Without Attorney. The other document is called Jefferson County Affidavit of Indians or Affidavit of Indians. And the last document is Waiver of Counsel for purposes of entering a guilty plea or proceeding the trial. I'm going to start off with the Judge's Explanation of Rights to Defendants Without Attorney. This is should be the first form. We'll start off with this, and I will constantly refer back and forth to this document. Now, this document states, that as a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Number 2, you may request that an attorney be appointed to represent you. And number 3, you may represent yourself. Now, the first 1-sentence paragraph in law number 3 states that if you want an attorney and you can afford to hire an attorney, your case will be reset to give you, sir, you need to sit up. Okay? Now, if you don't follow the rules of the court can hold you in contempt of court. You know what that means? It means you could be put in jail, in the county jail for up to 180 days, and you could be given a fine of $500. Okay? So you make the choice as to whether or not you're going to follow the rules of the court. Okay? You go to sleep at your house, not in court. All right? So the first sentence states that if you want an attorney and you can afford to hire an attorney, your case will be reset to give you time to hire an attorney. The next 1-sentence paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, then you can ask for an attorney to be appointed to represent you. But you must first sign a financial questionnaire. Now, a financial questionnaire is that 3-page document on the clipboard that is titled Jefferson County Affidavit of Interest. Okay, now this is only for people who will be applying for a court-appointed attorney. If you're not applying for a court-appointed attorney, you don't have to worry about filling out that form. Okay? Now, you will have to, now the financial questionnaire, as I mentioned to you earlier, looks like this. Now, for those of you who will be asking for a court-appointed attorney, you need to fill out this first page, and then you'll go to the second page, and in the second page, at the top, it says defendant's oath. You'll fill out the top portion, and then you'll fill out the middle portion that's titled unsworn declaration by defendant. Okay? And then you'll stop. Now, going back to that first form, judge's explanation of rights to defendants without attorney, the next one sentence paragraph is for individuals who will be representing themselves. First of all, you have a right to represent yourself. In essence, you have a right to act as your own attorney. But before you're able to do that, you have to sign a document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding Trial. Now, this is only for people who will be representing themselves. If you're not representing yourself, you don't have to worry about signing this form. You'd have to read and sign this form. Now, going back to the first document, that third paragraph, one sentence paragraph states that you may not speak to the prosecutor about your case unless you first sign a waiver of your right to have an attorney. This is for individuals who will be representing themselves. And the reason for that is once you waive your right to have an attorney, you will be representing yourself. In essence, you will be your own attorney. And so just like your attorney can talk to the prosecutors assistant criminal district attorneys that work for the Jefferson County District Attorney's Office, you'll be able to talk to them to see if you can settle your case. If you're able to settle your case, we call that a plea bargain agreement. Okay, now, this paragraph, the next paragraph is in block form. It states, and this is for individuals who will be representing themselves. They be aware that the dangers and disadvantages of self-representation, waiving your right to an attorney and representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of firearms, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, this last one sentence paragraph states that you may change your mind at any time and request that an attorney be appointed to represent you. Now, let's say, for example, you represent yourself and you talk to one of the prosecutors. Your idea is, well, I want to see if the prosecutor would just give me a fine for my offense. Talk to the prosecutor say, well, I'm not going to offer a fine, I'm going to offer probation. And you say, well, I don't want probation. Judge, I want to change my mind. I want to represent myself. Okay? You can do that. Now, at the bottom of this document, everybody's going to make a choice. In bold letters, it says defendant's choice. Mark initials only the one choice. Okay? There are 5 lines to the left of this document. Okay? If you would like to hire your own attorneys, you will place your initials on the first line to the left. That's for those individuals who will be hiring their own attorney. Then you will sign the document dated today's date, August 4th, 2026, and then you will stop. And this is the only form that you would have to sign. Now, if you have already hired an attorney to represent you, then you'll place your initials on the second line to the left at the bottom, and the name of the attorney on the line to the right. You'll sign your name at the bottom where it says defendant, dated today's date, and then you'll stop. And this is the only form that you would have to sign. Now, if you would like to apply for a court-appointed attorney, then you will place your initials on the third line at the bottom to the left. You will sign the form where it says defendant. You will date it today's date. And then you will fill out the form that is titled Jefferson County Affidavit of Indigence. You fill out the first page, and then you'll go to the second page. You'll fill out the top portion that's titled Defendant's Oath, and the middle portion that's titled Unsworn Declaration by Defendant, and then you'll stop. Now, if you have already been appointed a court-appointed attorney in this case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. Then you'll sign your name at the bottom where it says defendant and the day's date, and then you'll stop. This is the only form that you would have to sign. Now, if you would like to represent yourself, that is, waive your right to an attorney and represent yourself, you'll place your initials on the last line, the fifth line to the left, the name, and then you'll place your name on the line that's titled defendant, the day's date, and then you will read and sign the form that is titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial. Okay? Anybody have any questions before we go any further? Okay, no questions? Okay. Now, we're going to give you time to fill out that paperwork. I need to go over some more rights that you have. One of the rights that you have a right to have a trial by jury. In that area where you see those 12 chairs, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. The reason why it's 6 because in county court, you have 6-member jurors. In district court, this is not a district court, but in district court, you have 12. So 6 members from Jefferson County will be selected to serve as jurors. They will listen to all the evidence that's presented by the state, by the defense. They'll listen to the arguments of the state and the defense, and then they'll go back into that jury room to deliberate to see whether or not they will find you either not guilty or guilty. Now, you have a right to waive your right to have a jury trial, which means you can give up your right to have a jury trial. Now, if you give up your right to have a jury trial, you still can have a trial. The trial that you will have is called a bench trial. And it's a trial by judge. The judge will be the judge and the jury in the case. The reason why they call it a bench trial is because the judge sits on the bench. So the judge will listen to the evidence that's presented by the state, by the defense, listen to the arguments of the state and the defense, and then the judge will apply the facts to the law and decide whether to find you either not guilty or guilty. Now, if you waive your right to have a jury trial, you waive your right to have a bench trial, that means that you are interested in entering into a plea bargain. Now, you can enter one of 3 types of pleas. If you can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you committed the offense, that you did not commit the offense that you've been charged with. Or if you enter a plea of guilty, that you're telling the court that you committed the offense that you've been charged with. Or if you enter a plea of no contest, you're telling the court that you will not be contesting or you will not be fighting the charges. Now, if you enter a plea of not guilty, obviously, you're telling the court you either want a jury trial or a bench trial. If you enter a plea of guilty or no contest, you're telling the court you would like to enter into a plea bargain with the state. Now, there are 2 types of plea bargains. One type of plea bargain is called an agreed plea bargain, and the other type is called an unagreed plea bargain. And the difference between the 2 is as follows. With the agreed plea bargain, you and the state has come to an agreement. With the unagreed plea bargain, you and the state have not come to an agreement. So with the agreed plea bargain, you and the state has come to an agreement. And if y'all come to an agreement, you ask for a fine, they offer you a fine, you're happy with that, then it goes before the court. The judge can do 1 of 2 things. The judge can accept or reject the agreement. Now, if the judge rejects your agreement, then you can tell the judge, well, judge, since you're not accepting the agreement, I withdraw my plea or I take back my plea. In essence, I'm not pleading either guilty or no contest. You can do this. Now, if the judge follows the plea bargain agreement, then if you decide within 30 days of the plea agreement, 30 days, within 30 days of the case being disposed, I guess you could say, then if you decide that you would like to have a new trial and you'd like to appeal, you have to get permission from the court. Okay? And if the judge gives you permission, then the case gonna leave this here court right here, this court, and it's gonna go right upstairs to the Ninth Court of Appeals. There are four judges up there, four justices. They're going to review the case. And they can either grant or deny your appeal. If they grant your appeal, they can simply find you not guilty and the case is over. Or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your appeal, well, you can appeal it to a higher court than the Ninth Court of Appeal. You can appeal it to the highest criminal court in the state of Texas, and it's the Texas Court of Criminal Appeals, located in Austin, Texas. Now, you have to file what is called a pro se petition for discretionary review. I will explain that to you. Pro se means you represent yourself, and you're petitioning or you're asking the Texas Court of Criminal Appeals to review your case to see whether or not the Ninth Court of Appeals should have granted your appeal, or whether or not this court committed an error by wrongfully convicting you. They can do one or two things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty in case is over. Or they could, if they deny it, then at that point, your conviction will stand. Okay. Now, you also have a right to have witnesses to come to court. Witnesses sit in that chair that has the microphone in front of it. It's called the witness stand. And what witnesses do, they can testify for you, against you. If you're representing yourself, you can ask them questions. Or if you have an attorney representing you, your attorney can ask them questions. We call that either direct examination or cross-examination. You also have a right to waive your right to have witnesses, which means that you have a right not to call witnesses. Now, if you do not call witnesses, that does not mean that the state will not call witnesses, because the state will be calling witnesses in that case. You also have what is called a Fifth Amendment right against self-incrimination. I'll explain that to you. Fifth Amendment of the United States Constitution gives us a right to remain silent, which means that we don't have to testify. State can't call us to testify if we exercise or invoke our Fifth Amendment right against self-incrimination. Now, we can waive or give up that right. Now, if we waive or give up that right, then we will be testifying in our case. And I always use this example. It makes sense for us to have a Fifth Amendment right against self-incrimination. Why? Because the state of Texas has a burden of proof. They have to prove that you are guilty beyond a reasonable doubt. You don't have to prove yourself guilty. Okay? Now, the other thing is you also have a right to have discovery. And what discovery is, you have a right to see the evidence or have access to the evidence that's in the state's file. Whatever state has. We're talking about witness statements, your statements, police reports, lab reports, video recordings, audio recordings, photos, instruments, documents, whatever they have, you have a right to have access to the evidence. Now, you can waive or give up your right to have discovery, which means that you will not be having access to the evidence in your case. Now, everyone here today for a case, charges have been filed against you. You've been arrested, placed in the county jail. You have bonded out either on a cash bond, which means you paid the full amount of the bond to get out of jail, or you bonded out on a surety bond, which means you pay a bondsman a percentage of the bond to get out of jail, or you bonded out on either a PR bond or a personal recognizance bond, which means you did not have to pay any money to get out of jail. You were released from jail under your own personal recognizance with a promise to appear here today. I said that to say this. Every day that you spent in jail can be used as credit toward your offense. So, for example, the operative word is every day. So if you were for example, arrested and booked into jail at 11 p.m. on last night, 11:59 p.m. of last night, and then you booked out of jail at 12:01 a.m. this morning, which is 2 minutes. You get credit for 2 days. You only spend 2 minutes in jail, but you get credit for 2 days. Why? Because yesterday was Monday and today is Tuesday, 2 different days. Okay? And so, let's say, for example, you spend 5 days in jail, state is offering you 5 days in jail to settle your case. That simply means you will not have to serve any more time in jail. Why? Because you will get credit for time served. Now, if they're offering 7 days in jail, you spend 5 days in jail, you will only have to spend 2 days in jail because we'll subtract 5 from the 7 and leave 2. Every day that you spent in jail also can be used as credit toward, you get credit, it can be used as credit towards your fine and court costs. Every 1 day that you spend in jail, you're credited $100 per day. So if you spend 5 days in jail, that's $500 that can be used toward fine and court costs. So if the state is offering you fine and court costs of $500, guess what? You don't have to pay anything because the time that you spent in jail has already paid it off. Now, if they offer fine and court costs of $700, that simply means that you only have to pay $200 because we will subtract the 5 that you already have from the 700, and that leaves 200. Now, once the case is disposed of, you'll be required to pay the balance on that day. If you cannot pay it, no problem. Why? Because we can put you on what is called a payment plan. In essence, you can pay it off in small monthly installments until it's paid off. Now, let's say, even if we put you on a payment plan, you can't pay it off because you do not have the income, no problem. Because we could convert your fine and court costs to community service. And for every 1 hour of community service that you perform at a nonprofit organization, $12.50 will be credited toward the payment of your fine and court costs. So for example, if you work 8 hours in 1 day, what is 8 hours? That's $100. So in our scenario, if you're $200, you work 2 8-hour days, that's $200, and your fine and court cost balance is paid off. Okay. Now, Jefferson County District Attorney's Office has a program for individuals who, I guess, is being charged for the first time for 1 or more cases. The first time. With that program, they will dismiss your case and you can get it wiped off your record. The program is called pretrial diversion. In order to qualify for pretrial diversion, 3 things has to happen. 1, has to be your first time having charges filed against you for 1 or more cases. 2, it cannot be an offense for unlawful carrying a weapon or resisting arrest. And 3, you have to have an attorney to assist you with the application process. Now, the attorney does not have to be hired. You can have a court-appointed attorney to get you into the program, okay? If you get into the program, you complete the program, they will dismiss the case, and you can get it expunged from your record. Expunged means erased, deleted, or wiped off like it never happened. Okay. The District Attorney's Office has another program for veterans. It's called Veterans Court. Only thing you have to do to be in the program is to be a veteran of any one of the branches of the United States military. And with that program, what they will do, once you complete the program, you can get it erased, deleted, or wiped off from your record like it never happened. Okay? It don't have to be your first time. It's just Veterans Court. You just have to be a veteran. Okay? In the office. All right. Now, this court, County Court of Law Number 2, Jefferson County, Texas, has a program that God led me to start in the first 100 days of taking office in March of 2017. The program is known as the CSI program. CSI is an acronym that stands for Community Safety Initiative. And with that program, the program is designed to address the issue of what is called recidivism. Recidivism is where people commit crimes over and over. And so with the program, we have partnerships with various agencies in the community. And one of the partnerships that we have is with the Spindletop Center. Spindletop Center is our local mental health center in the Southeast Texas region. And we have some folks from Spindletop here today that's going to come and tell you a little bit more about the program. But basically what Spindletop can do today, they can have a private interview. Then they can do an assessment to determine what your mental health issue may be. And then they develop a treatment plan for either outpatient or inpatient treatment. Now, in order to participate in the program, you do not have to be incompetent or insane. You can merely suffer from depression or anxiety or any other host of mental illnesses, and they have the ability to address those issues. They have doctors, counselors, mental health officers, and a number of people that work in that facility. Now, if you have issues with drugs or alcohol, then we have a program where we have a partnership with Spindletop. Spindletop has a program that is called ATAR. ATAR is an acronym, ATAR, that stands for Addiction Treatment and Recovery. We also have a partnership with our local Drug and Alcohol Council that has a program that is called OZAR. OZAR is an acronym, OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And with those programs, what they can do well, first of all, they can do a screening, which is an interview. Then they can do an assessment to determine what your issues are with drugs or alcohol. And then they can develop a treatment plan for either outpatient or inpatient treatment. If you have not graduated from high school, or if you do not have a GED, then Spindletop, as well as CICE, has a program where you can get your graduate equivalency diploma. Now, the partnership that we have, if you're not working, or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University, and Lamar University has a program that's called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. And once you're trained in any one of those areas, it will help you to get a job in the area that you've been trained in. Now, with those programs, all of those programs that I just mentioned are free, does not cost you anything but time. And I like to say in this court, we do not just give time, we take our time. And that simply means we do not just arrest the problem, we address the problem. And if we address the problem, we believe that we produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to County Court at Law Number 2 in Jefferson County, Texas, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs that I just mentioned, just let us know. And we have people here that you can talk to so that you can get on the road to live your best life. So as I mentioned to you earlier, we have some folks here from Spindletop. They're going to come and tell you a little bit more about the program that Spindletop has to offer. Okay. We have Mr. Green, Deputy Butler, and Ms. Connie.
Good morning, everybody. I'm Deputy Butler in the Jefferson County Sheriff's Office. I'm the liaison officer for Stabletop. I'm the one that would, get you hooked up with various, resources that is needed to assist you. I'm also, if you become a full-time client, you have a doctor's appointment, you don't have a ride to make it there. I'm the one that would, be right there and back. This is my partner, Ms. Latanya. She's a qualified mental health professional. If you want to speak with anyone, you will speak with her privately. Whether it's said between you and her, it's kept there to be for help or harm. You don't want to violate anybody's right. Mr. Jerry Green is also a qualified mental health professional. Also, Ms. Latanya, she's going to tell you more about this phone call program.
Good morning, you guys.
Good morning.
As Deputy Butler said, and Judge Holmes, we have this program available for you guys. If you need substance use or mental health use, we can get your information set today. We do text, call, or email. With these options that are provided, there's totally optional. But we would like you guys to receive assistance if needed with the substance use. Those hours, if you're needing them, we can help you guys get those hours set at our facility. If you're needing any mental health assistance, we have that available also. We would have a therapist on site, we would have psychiatrists on site. If you guys would need any medication, we have a pharmacy on site. This is one that most people, I know, everyone, when they hear mental health, they all think of that R word. When I say that R word, you guys know what I mean, but you're not thought of that way. Anyone that's getting help, you need help. If you're willing to speak with us, maybe they provide some type of help. If you do speak with us, you are covered by the HIPAA law, and anything you tell me or Deputy Butler, I can want to be released. We'll give you guys a few moments so you can fill out the form if need be. If not, we would like our form fixed. Any questions? You guys have a good day.
Okay, thank you, Latanya, Deputy Butler, and Mr. Green.
Yes, sir.
Okay. Okay, now, ladies and gentlemen, the paperwork that you have, I'm gonna give you time to finish filling out that paperwork. If you need any assistance with filling out the paperwork, we have our full personnel, including myself, who will be happy to help you, assist you with filling out the paperwork. Now, it's gonna take a few minutes, some time for you to fill out the paperwork. And then, so if you need to use the restroom, there's two restrooms right out in the hallway. We have the male restroom or the men's restroom in front of Concord Elementary, on the opposite side of the hall, in front of the 172nd District Court. And we have the women's restroom. You'll be allowed to use the restroom. Please do not leave the courthouse. Come back into the courtroom, because if you do not come back into the courtroom, if you leave the courthouse, and if your name is called and you do not answer, then your bond is gonna be forfeited, which means that a warrant is gonna be issued for your arrest. You'll be arrested, placed back into the county jail, and then once you bond out, we're gonna have to go through this all over again, okay? So we're gonna try to get you in and out as soon as possible. If you need help, just let us know. Again, we have our court personnel who will be here to help you with filling out the paperwork. Now, be mindful, first of all, you're still in court, so conduct yourself accordingly. And we're gonna put you in one of three categories. If you would like to hire your own attorney, then you will be placed in that category, and then your case will be reset, which means that you'll be given more time to hire your attorney. You'll be given another court case. If you would like to apply for court-appointed attorney, if you qualify for a court-appointed attorney, then you will be appointed a court-appointed attorney the day before you leave here. And if you would like to represent yourself, you'll have an opportunity to talk to one of the prosecutors about your case, and if you're able to reach an agreement, then the case will be disposed of today. Okay, so we're getting ready to go into recess, and before I do that, if you look at the top of that first document, judge's explanation of rights to defendants without an attorney. The top left-hand corner states, state of Texas versus, and there's a blank line. Print your name on that line. Because if your name writing black line, sometimes I can't read it. And so we want to make sure that we know who the application and the form are for. Okay? So, yes, yes,
You're talking about expungement of the case. Does that also expunge the arrest?
everything.
Everything? Okay.
Yeah, it's why I used to use this here example. The example is like this here. Your record looks like this, right? After it's expunged, it looks like this. Okay.
Thank you.
Okay. Anybody else have any other questions before we go into recess? Yes, I see you like you.
Yeah, so like if I wanted to hire my attorney, cause I got 3 of them up on top two, some of them high,
All right.
but so if I wanted to. See with that, then you see what they're gonna charge first, is there any way that I can contact your office and say, hey, I'm gonna do it?
No. Okay, okay, I think what you're saying is you want to see if you can hire an attorney.
Basically,
Okay.
it'll be
If
charged.
you can't hire an attorney, well, first of all, your case is gonna be if you say you wanna hire an attorney, your case is gonna be reset, you're gonna give another court date. When you come back on that court date, you tell us that, you can't hire an attorney, you wanna see if you qualify for a court appointed attorney. Or maybe you wanna represent yourself, so I'm just saying those are the options, those options are still available.
Yes.
Is what I'm saying.
That's what I just double checked, I just wanted to.
Yeah. Sometimes, I don't think everybody charges the same price. It varies, so.
Yes, sir.
Anybody else? Okay, so the court is gonna be in recess. Please conduct yourself accordingly. Jefferson County Court Law number 2 is back in session. Court is in session with its arraignment docket. First case is cause number 26 CCCR 1606. Case is styled the state of Texas versus Ronnie Brooks. Brooks, would you please come forward? In the front, in the middle, okay. Mr. Brooks. Your full name is Ronnie Brooks?
Ronnie Brooks.
Okay, Mr. Brooks, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you out?
Yes, sir.
Mr. Brooks, you may put your hand down. Mr. Brooks, how are you doing?
Okay.
That's good. Now, Mr. Brooks, I have before me, prosecutor, Miss Farrah Nixon. Miss Nixon, how are you doing?
I'm fine, Your Honor. How are you today?
I'm doing fine, thanks for asking. And Mr. Brooks, I also have a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes,
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you would like to have your case reset to hire your own attorneys? Before you sign this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Brooks, I read your answers. Your case will be reset. There you go. You're gonna get your reset from our court administrator. Once you get your reset, you're free to go and you have a blessed day. Darius Johnson.
Morning.
Come on. Mr. Johnson,
Yes, sir.
your full name is Darius Sherrod Johnson.
Correct.
Mr. Johnson, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Johnson, you may put your hand down. How are you doing, Mr. Johnson?
I'm blessed. How about you?
I'm blessed as well. Thanks for asking. Now, Mr. Johnson, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, it is.
And are these your initials on the line that states you'd like to have your case reset to hire your own attorney?
Yes, it is.
Before you sign this document, did you read the document?
Yes, it is.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Correct.
Okay, Mr. Johnson, I read your answers. Your case will be reset to give you opportunity to hire your own attorney. Our court coordinator is going to give you a reset. Once you get your reset, you're free to go and you have a blessed day.
You too. I appreciate it.
Thank you. Next case. Jonathan Jasper Lavoy. What do I have to tell him in the keyboard? Okay, everyone, that door over there is locked. Okay, next case is cause number 26CCCR 1634, case of style of the state of Texas versus Jonathan Jasper Lavoy. And Mr. Lavoy, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Lavoy, you may put your hand down. How are you doing, Mr. Lavoy?
Not bad. How are you?
I'm doing fine, thanks for asking. Now, Mr. Lavoy, the state is represented in this case by attorney Denise Williams. Mr. Williams, how are you doing?
Very well, Your Honor. Thank you. And how are you and your exceptional staff this day?
We're doing great, thanks for asking. Now, Mr. Lavoy, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes, sir.
Before you sign this document, did you read it?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Mr. Lavoy, your case will be reset. Our court administrator will give you a reset. Once you get your reset, you're free to go
Thank you.
and you have a blessed day. Thank you. Alejandro Copian. Mr. Compian, your full name is Alejandro Compian.
Yes, sir.
How are you doing?
Good, how are you?
I'm doing fine. Would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You may put your hand down. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line as titled defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Now, Mr. Copian, before you sign and initial these documents, did you read the documents?
Yes, sir.
You understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Copian, I read your answers to these questions. You meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Laura Perazo. Attorney Perazo will be given information to contact you. You will be given information to contact her. Our court coordinator, our court administrator will give you that information. Once she gives you that information, you're free to go and you have a blessed day.
Thank you, sir.
Charles Shaw. Okay, Mr. Shaw. Full name is Charles Edward Shaw, is that correct?
Yes.
Mr. Shaw, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Mr. Shaw, you may put your hand down. How are you doing, Mr. Shaw?
Doing all right, how you doing?
I'm doing fine, thanks for asking. Now, Mr. Shaw, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
Is this your signature on the line that's titled defendant?
Yes.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes.
Now, Mr. Shaw, before you sign and initial these documents, did you read the documents?
Yes.
You understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Mr. Shaw read the answers. You meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be. What's the DWI? The attorney that will be appointed to represent you in this case is Attorney John Macy. Attorney Macy will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Here you go.
Thank you.
I put the wrong. 1584. Michael Tello? Okay. Your full name is Michael Anthony Tello II?
So,
Okay, Mr. Tello, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
so,
Mr. Tello, you may put your hand down. How are you doing, Mr. Tello?
I'm doing all right, how are you?
I'm doing fine, thanks for asking. Man, this is an old case. This case was filed in 2020. Let's see, it took them 6 years to release it like this. Let's see. Well, then, 2020. Yeah, took them 6 years to arrest. Okay. Okay, now, Mr. Tello. I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that titled defendant?
Yes, sir.
Are these your initials on the line that state you like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled defendant's signature. Is this your signature?
Yes, sir.
Now, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes.
Tello, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. The attorney that is appointed to represent you is Attorney Todd LeBlanc. Attorney LeBlanc will be given permission to contact you, and you will be given permission to contact him. Our court administrator will give you that information. Once you get that information, you'll be free to go. And you have a blessed day.
Thank you, sir. You too.
You're welcome. John Baptiste? Now, Mr. Baptiste, your full name is John Baptiste.
Yes, sir.
Baptiste, would you please raise your right hand? Do you swear affirm and tell the truth, the whole truth, and nothing but the truth, so help you God? Baptiste, you may put your hand down. How are you doing, Mr. Baptiste? I'm doing fine. Thanks for asking. Mr. Baptiste, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant?
Yeah.
Are these your initials on the line that state you like to apply for a court-appointed attorney? Also, I have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of this same document, there's a signature above the line that's titled Defender Signature. Is this your signature?
Yes.
Now, Mr. Baptiste, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, Mr. Baptiste, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you, in this case, is Attorney Giles Cole. Attorney Cole will be given information to contact you, and you will give information to contact him. But our court administrator will give you that information, but before she gives you that information, bailiff is going to hand you a document that is titled Standard Bond Conditions. And Mr. Baptiste, do you have that document?
Yes, sir.
I'm going to go over this document with you, and it states, following a return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? Now, condition number 3 states that the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that? Now, condition number 4 does not apply. However, condition number 5 does apply on the next page. And it states, defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer, as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Mr. Tatis, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that? Okay. You're gonna get your reset from our court coordinator. Once you get your reset, you're free to go. You have a blessed day.
It's your turn, his name. That's the next person. He should be.
Shaquita Allen.
This is a regulation. Thank you.
Ms. Allen, your full name is Shaquita Allen?
Yes, sir.
Ms. Allen, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth,
Yes,
and nothing but the truth, so help you God? Ms. Allen, you may put your hand down. How are you doing, Ms. Allen?
I'm doing okay. How you doing?
I'm doing fine. Thanks for asking. Ms. Allen, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
Or these your initials on the line that state you'd like
Yes,
to
sir.
apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials, excuse me, a signature above the line that is titled defendant's signature. Is this your signature?
Yes, sir.
Now, Ms. Allen, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your
Yes,
knowledge?
sir.
Mr. Allen, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Ms. Jennifer DeLage. And Ms. DeLage will be given information to contact you. And you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go and you have a blessed day.
You have a blessed day.
Okay, stand in front of the court coordinator. Next case is Naomi Benoit. Ms. Benoit, your full name is Naomi O. Benoit.
Yes.
Ms. Benoit, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Benoit, you may put your hand down. How are you doing, Ms. Benoit? I'm doing fine, thanks for asking. Ms. Benoit, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And on page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes.
Now, Ms. Benoit, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Benoit, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney David Grove. Attorney Grove will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day.
That's your next court date. You should be contacted before then. That's just before the day. That's his information. Thank you, thank you.
Next, two cases. Diamond Green, cause number is 26CCCR 1588 and cause number 26CCCR 1727. It's 1707. Ms. Green, your full name is Diamond Green. Ms. Green, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Green, you may put your hand down. How are you doing, Ms. Green? I'm doing fine, thanks for asking. Ms. Green, I have before me State Prosecutor Attorney Samuel Masradian and Attorney Masradian. How are you doing?
Doing well, Judge. Thank you.
You're welcome. Now, I also have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes.
Or these your initials on the line that state that you would like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And on page 2 of this same document, there's a signature above the line that is titled Defendant Signatures. This is your signature. Now, Ms. Green, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Green, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Langston Adams. Attorney Adams will be given information to contact you. You'll also be given information to contact him. And our court coordinator will give you that information, but before she gives you that information, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that document?
Yes.
I'm going to go over this document with you, and it states, following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for the release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed, the court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim. In this case, we have 2 cases with alleged victims of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that? Condition number 4 doesn't apply, however, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer, as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Ms. Green, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Okay? Now, this will conclude your case. You're going to stand before our court administrator. She's going to give you your reset. Once you get your reset, you're free to go, and you have a blessed day. We have any more paperwork? I have 2 documents, but I think we have 3 people out there. Oh, you do? Macy McKenzie? Macy McKenzie?
We just have to be, it's a motion to withdraw. That's you.
Okay, Miss McKenzie. There's 2 cases. You have 2 cases. Cause numbers. Well, you have 2 cases. Cause numbers 26CCCR 1628 and cause number 26CCCR 1629. Both cases are styled of the state of Texas versus Macy Lyric McKenzie. Miss McKenzie, is that your full name? Miss McKenzie, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Miss McKenzie, you may put your hand down. How are you doing, Miss McKenzie?
All right.
That's good. Now, Miss McKenzie, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
And are these your initials on the line that state you like to apply for a court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of this same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes.
Now, Miss McKenzie, before you signed and initialed these documents, did you read the documents? And did you understand what you read?
Yes.
And is everything in these documents true and correct to the best you know?
Yes.
Okay. Miss McKenzie, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in these cases is Albert Price. Attorney Price will be given information to contact you. And you will be given information to contact him. The court reporter will give you that information, well, the court coordinator will give you that information. Let's see. Yeah, well. Now, once the court coordinator give you that information, you'll be free to go. And you have a blessed day. Please stand in front of the court coordinator. Stacy Lawrence. No mysteries. Okay, this is cause number 26 CCCR 0342. The docket sheet has you as the Stacy Lawrence. Is that your full name? Okay, you have to speak up. You don't nod your head. Okay, we're not doing sign language. Okay. Now, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you may put your hand down. How are you doing? You all right? Okay. Now, Mr. Lawrence, I have before me a document that is titled Judge's Explanation of Rights, Defendants Without an Attorney. Do you recognize this document?
Yes.
Is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you like to waive your right to an attorney and represent yourself?
Yes.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And is this your signature on this line that's titled Defendant? Now, before you signed and initialed these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct
Yes.
to the best of your knowledge? Is that correct? And you have talked to the prosecutor about your case. Is that correct? And
I ain't really.
they offered you they offered you a plea bargain. Is that correct?
Yes.
And you rejected it. Is that correct?
Yes.
Okay. Now, Mr. Lawrence, I need to read you what is called a Faretto warning or admonishment. This is from the case of Faretto versus California, 422 US 806 of 1975 case. I need to ask you some questions. Have you ever studied law?
No.
Okay. Have you ever represented yourself in a criminal action? You have to speak up.
No.
Do you understand the charge against you?
I don't know what I'm being charged with as far as the misdemeanor.
Okay, you've been charged with a assault causing bodily injury to a family member. That's the charge. You understand that?
Yes, sir.
All right. Now, that's a class A misdemeanor.
Gotcha.
Okay, and I think I mentioned to
Yeah,
you.
up to a year in jail, $4,000 fine.
Right. Okay. Now, are you familiar with the exact legal elements of the charge? What has to be proven by the state?
Yes.
And do you realize that if you are found guilty, that you mentioned the punishment range, you could be assessed punishment anywhere within the punishment range. You understand that? Okay. Now, do you realize that if you represent yourself, you are on your own? That means that as a judge, I cannot tell you how you should try your case or even advise you as to how to try your case. I cannot help you in any way. Do you understand that?
Yes.
Are you familiar with the Texas rules of evidence and Texas case law?
Yes.
You are. Okay. Do you realize that the Texas rules of evidence and Texas case law govern what evidence is admitted? And in representing yourself, you must abide by those rules. For example, how do you know how to conduct a voir dire examination? Do you know what are the grounds for excusing a juror for cause? Do you know what is hearsay?
No.
Do you know what are some of the exceptions to hearsay? Okay. Do you know what is the proper impeachment or how to properly impeach a witness? Do you know when is character evidence allowed into trial? Do you know when and how to make proper objections? Do you know when and how to move for a directed verdict?
No.
Do you know how to offer evidence to protect the record for appeal? Do you know the proper grounds for mistrial?
No.
Are you aware that failure to timely move for a mistrial may waive crucial mistakes made by the state or this court? Okay. Do you know how to request and object to jury instructions? Are you familiar with the Texas rules of criminal procedure? Do you realize that those rules govern the way in which a criminal action is tried in court?
No.
Okay. Now, I must advise you that, in my opinion, you would be far better defended by a trained lawyer than you can be by yourself. I think it is unwise for you to represent yourself. You're not familiar with the law. You're not familiar with court procedure. You're not familiar with the rules of evidence. I would strongly urge you not to try to represent yourself. Now, in light of the penalty that you might suffer if you are found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by a lawyer?
Yes.
Okay. Is your decision entirely voluntarily on your part?
Yes.
Okay. So I find that the defendant has knowingly and voluntarily waived his right to counsel. I will therefore permit him to represent himself. Okay. So your case is going to be reset. Now, your case is going to be reset. That'll give you some time to set up an appointment with the district attorney's office to have discovery so that you can have access to the evidence that the state has against you. Do you understand that?
Yes.
Okay. So you're gonna stand in front of our court coordinator, you're gonna get
It's an
your,
assault family, could you,
oh, matter of fact, I have his things right here. Now, Mr. the Stacy Lawrence. I also have before Miss Bailiff, would you please hand these documents to Mr. Lawrence? Miss Mosby? Would you please hand these to the defendant?
I can't.
Here you go. Now, Mr. Lawrence, You just been handed a document that is titled Standard Bond Conditions in County Code Law Number 2. And it states following return of a criminal information in County Code Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes.
Now, condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that conditions? Now, condition number 3 states that the defendant shall now communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Now, condition number 4 does not apply because that applies in a DWI case. In your case, it's not a DWI case. Condition number 5 does apply. And condition number 5 states, defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Okay, now, Mr. Lawrence, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes.
Okay. There you go. So, Mr. Lawrence. There you go. Y'all need him to have a seat. Y'all working on anything?
Thank you.
Hold on, just have a seat. Have a seat right there. Okay, Jefferson County Court at Law number 2 is back in session. The court is in session. That he wants to set up a discovery, okay. Court is back in session at cause number 26 CCCR 1584. Case is styled the state of Texas versus Noe R. Marino. And Mr. Marino, is that your full name?
Yes, sir.
Mr. Marino, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Marino, you may put your hand down. How are you doing, Mr. Marino?
Doing good, where's it?
That's good. Now, Mr. Marino, I also have before me, now, Mr. Marino, before we get started, you have a right to have a court reporter to type down or dictate everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you understand that?
Yes, sir.
Now, do you waive or give up your right to have a court reporter?
I will.
You waive? Okay. Now, Mr. Marino, I have before me on my computer a document. Well, I have two documents on paper. First two documents are titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you like to waive your right to attorney
Yes,
and
sir.
represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Marino, I also have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Noe R. Marino, on or about March 30th of 2025, while you were operating a motor vehicle in a public place in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated. Second, Mr. Marino, do you understand what you have been charged with?
Yes, sir.
And to this charge, well, also prior to the commission of this offense, this information further alleges that on November 27th of 2017, in cause number 229309, in the County Court at Law number 4 of Brazoria County, Texas, that you were convicted of an offense relating to the operating of a motor vehicle while intoxicated. Do you understand that?
Yes, sir.
Is that true or not true?
True.
Now, to the Class A misdemeanor of driving while intoxicated, second, while you were operating a motor vehicle in a public place in Jefferson County, Texas, on or about March 30th of 2025 in Jefferson County, Texas, how do you plead guilty, not guilty, or no contest?
No claim.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Marino, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit number 1. Oh, you got it. Now, State, are you abandoning enhancement paragraph?
Yes, Your Honor. Sorry.
Oh, let me back up. So, Mr. Marino, the state is abandoning an enhancement paragraph. And so what that basically means is instead of being charged with a Class A misdemeanor DWI driving while intoxicated second, you'll charge with a lesser included offense, driving while intoxicated first, which is a Class B misdemeanor. Do you understand that?
Yes, sir.
Okay. Let's see this. Now, to the Class B misdemeanor offense of driving while intoxicated while you were operating a motor vehicle in a public place in Jefferson County, Texas, how do you plead? Guilty, not guilty, no contest.
I'm sorry?
Class B misdemeanor offense of driving while intoxicated first, how do you plead? Guilty, not guilty, and no contest? No contest. Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Now, Mr. Marino, I also have before me on this computer tablet a document that is titled Misdemeanor Plea Admonishment. There's one box that's checked. It had initially, it was a Class B. Now, this is a Class B misdemeanor, but it's a Class B DWI. And so the range of punishment for a Class B misdemeanor DWI is minimum 72 hours in the county jail to a maximum of 180 days in the Jefferson County Jail. Do you understand that?
Yes, sir.
Or you could be given a fine that does not exceed $2,000. You could be given both such fine and confinement. Do you understand that?
Yes, sir.
Okay. Now, on page 2 of this same document, there's a set of initials NM. They're in 2 locations. The top location on a line next to a box that's checked nolla contendere, which means no contest. You place your initials on this document.
Yes, sir.
The second set of initials are on a line next to a statement that reads, I do not request discovery. I waive my right to discovery in this case, and I choose to enter a plea of guilty and no contest. Did you place your initials in this document?
Yes, sir.
The second location. On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Also, now, Mr. Marino, before you signed and initialed all of the documents that I showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Marino, you go. Are you a citizen of the United States?
Yes, sir.
State offers State's Exhibit 1.
Here you go. Mr. Marino, the state is offering State's Exhibit number 1 to be used as evidence in your case. State's Exhibit number 1 is the first document that you acknowledged on this tablet. This is the same document that has your initials in these 2 locations. It also has your signature at the top of this document on page 3.
Yes, sir.
Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objections. State's Exhibit number 1 will be admitted. Mr. Marino, is there any evidence that you are currently mentally incompetent to stand trial? Is there any evidence that you are mentally ill And you do not know, that you do not understand what's going on? Okay, so I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what's the agreement?
The central terms as follows: 180 days in county jail probated over 15 months, a $1,500 fine, no community service interlock, and DWI first standard conditions, and the work order.
What's the court cost?
Three. $397.
Okay, Mr. Marino, the state is offering that you serve 180 days in Jefferson County Jail, but you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 15 months. During the 15-month probationary period, you'll be required to pay a fine of $1,500. You'll be required to pay a probation fee of $397. You're required to pay DWI conviction fine fee of $100. You're required to pay probation fee of $60 a month, urinalysis fee of $15 a month, reimbursement fee of $15. You're also required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is the total amount that you will be required to pay each month, is $224 a month. Will you be able to pay the $224 each month?
Yes, sir.
Okay, you'll also be required to install an interlock device on any vehicle that you own or operate, attend a completed DWI education class, have an alcohol assessment, adhere to or follow all of the conditions of DWI probation. And the court has before it an order amending conditions of probation to allow you to travel outside of Jefferson County for employment. And is this your signature?
Yes, sir.
Okay, before you sign the document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, so I'm signing this document that allows you to travel outside of Jefferson County for employment purposes only. Okay, now, here you go. Now, Mr. Marino, do you understand the state's offer?
Yes, sir.
Do you accept the state's offer?
Yes, sir.
Okay. And Mr. Marino, do you think the state's offer in your case is fair and just?
Yes, sir.
Okay, Mr. Marino, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Marino, you're gonna stand in front of our court coordinator. She'll give you your reset. Once you get your reset, you'll be free to go. What did I say? Okay. Oh, no, not a reset. Just stand next to the bailiff and follow her directions. Once you finish following her directions, you'll be free to go and you have a blessed day.
All right, you too, thank you.
Okay.
When low,
Okay, I need to state abandon this.
Yeah. Yeah, go to the address, there you go.
What is this? Not doing anything. Send doc. Oh. Okay,
Thank you.
let's see. Okay, Jefferson County Court at Law number 2 is back in session. Court is in session and calls number 26 CCCR 1576. Case to style the state of Texas versus Sandra Hollyfield. Sandra Hollyfield is scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Sandra Hollyfield at the courthouse door. Sandra Hollyfield did not answer. A reasonable time has passed to give Ms. Hollyfield an opportunity to appear in court. She has not appeared in court. State. Ms. Bailiff, would you please call the name of Sandra Hollyfield at the courthouse door?
Yes. Sandra Hollyfield, Sandra Hollyfield. No response. Go.
Okay, Sandra Hollyfield name was just called again at the courthouse door. Sandra Hollyfield did not answer. A reasonable time has passed to give Ms. Hollyfield an opportunity to appear in court. State, do you have a motion?
Yes, Your Honor. State moves for bond forfeiture.
That motion will be granted. Sandra Hollyfield bond will be forfeited. A warrant shall be issued for her arrest in cause number 26 CCCR 1576. Next case on page 5, Bailey Moras. It says no image to verify address.
Can we reset her? Oh,
Yeah.
let me see if there's any now.
So what you want to do?
We can reset it next time. Yeah. I didn't know what it is.
Okay. Next case is Brian O'Neill Schenkel, page 6. Cause number 25 CCCR 0342, case of style state of Texas versus Brian O'Neill Schenkel. Brian O'Neill Schenkel was scheduled to be in court this morning at 9 a.m. At about 9 a.m., Brian O'Neill Schenkel name was called at the courthouse door. Brian O'Neill Schenkel did not answer. Is not appearing in court since the court has been in session. The time now is 12:42 p.m. on today's date. Ms. Bailiff, would you please call the name of Brian O'Neill Schenkel?
Brian Schenkel.
Yes.
Brian Schenkel. Brian Schenkel. No response, John.
Okay, Brian Schenkel's name was just called again at the courthouse door. Brian Schenkel did not answer. A reasonable time has passed to give him an opportunity to appear in court. It's not appearing in court. State, do you have a motion?
Yes, Your Honor. State moves for bond forfeiture.
That motion will be granted. Brian Schenkel's bond will be forfeited and warrant should be issued for his arrest in cause number 25 CCCR 0342. And this will conclude the calling of the court's Raymond docket on today's date, August 4th, 2026, in County Court at Law number 2. Judge Terrence Holmes presiding. Court will be in recess till, I'm saying 1:45.